Welcome to The Lift, an initiative by the Architects Alliance, where we elevate your understanding of built environment issues one floor at a time. This is our episode 5, and I am your host, architect Irene Aguttu.
Good morning. My name is Alfred Ndambiri, a lawyer by profession and also a practicing advocate. I have a big interest in matters relating to law and development, and more so those that are in respect to the land use and planning as provided under our newly enacted laws on planning and also based on the principles of our Constitution. I have been practicing for the last 37 years.
Thank you very much, Alfred. I'm just doing quick calculations. At 37 years, you
Yes.
should be...
Yes.
Shouldn't you have one foot in the grave and another one on a banana peel? But just kidding.
No, I take it.
So that tells me that you have a lot of experience.
Well, at least I've gone through many challenges.
Many challenges, and you have seen this city actually transform from whatever it was 37 years ago within your practice to what it is now. Now, if we look at the reality of the city of Nairobi today, we may want to remove our heads from the sand and look at ourselves in the mirror.
Yes.
As residents and practitioners and built environment practitioners and all other professionals that live and work in Nairobi.
Yes.
And tell ourselves the truth. Nairobi is in chaos.
Right.
It is in complete chaos and nothing seems to be working, to the point where we ask ourselves, do we have any laws that govern development or that govern planning in this city?
Well, the true position is for as long as I can remember, have had laws or have had proposed laws or have had proposals by way of word of mouth or proposals relating to sessional papers that have been drafted and even discussed upon. But when you're dealing with matters relating to planning for the city of Nairobi, the last time we had a legalized plan was way back in 1948. And after going through so many years of various, governments, as it were, and even commissions trying, to come up with proposals, it's only in the year 2019 that out of a legislation that was enacted in August of that year, there is now a law that we ought to be following, and we must follow it if we are to talk about any development plans for this city. It is called the Physical and Land Use Planning Act. More than now 5 years from the time it was enacted, but has not been utilized, has not been used at all by the authorities.
So what we are basically saying, Alfred, is that from the year 2019, we have had a law governing our development.
Yes.
But it has not been, it was enacted, but it is not being followed.
Yes.
And before that, we can safely say that it was the wild, wild west.
In fact.
Nairobi was just the wild, wild west before that.
What we used to have are topics, discussions, and even, litigations, where people, for example, staying in a Kilimani area, Parklands area, Pipeline area, Korogosho, would be told we have laws relating to zoning. We have laws relating to regulations on what type of development you can come up with. But when you look at what was being called rules, regulations, they were never laws. They were only proposals. And we've been operating on those proposals since then. That is why I agree with you. We've been in a wild, wide west in as far as planning of the city of Nairobi is concerned.
Which is quite unfortunate because, as you can see, the landscape is deteriorating, the environment is falling apart, all the infrastructure is falling apart, and so on and so forth. But let's now move to 2019, when there was some semblance of order and we got an act, an act of parliament in the form and shape of PLUPA. What does PLUPA tell us? And when I speak of PLUPA, because now we are without necessarily having to, get too technical. When I speak of PLUPA, what I mean is that there's a Physical Land Use and Planning Act, which is what is governing our planning laws. So I will refer to it as PLUPA moving forward. It's not jargon. It's just quicker to say. What does PLUPA tell us?
See, this is a law that was enacted principally to have, the national government, the intercounty associations, the county government, and local, call them local institutions, have directions on how they ought to bring changes, or if they want to make any changes to the land where they live, the various acts, the various steps they must go through. And those acts are contained as provisions in that PLUPA. So it's a law that generally tells us, the entire country, this is what you must do. Don't assume that you will, for example, be allowing development or construction, of high-rise buildings just because you have had somebody say, I have billions of shillings and I am able to put up, up to 40 floors. No, it is the law that says if you have that capacity, that ability, then follow the procedures, which includes get the various authorities to grant you permission to do that which you intend to do. And we have in that act a very crucial aspect. And unfortunately, I really doubt whether in all the county governments, anyone, responsible in matters relating to development is aware that you must have a consultative forum that enables you, as the leader, have information, ideas on how best to develop a plan, a development plan. It is called. We have three types of forums. For the national government, there's the National Physical and Land Use Consultative Forum. And then when we come down to the county governments, we have the County Physical and Land Use Consultative Forum. Every county today ought to have that forum. It is because the law says you must have it. And it is a forum which ought to be constituted by the various ministers, because in the county governments you have ministers. They are called the County Executive Committee members. You have the various ministers relating to urban development or even land use. In Nairobi, we actually call it, the minister is in charge of built environment and land use. Then you also have the ministers in that county who is in charge of urban roads, the minister in charge of environment, the minister in charge of health. Those must be members who form part of that forum. Then you move out of that government, because governance is about, citizens, and the general public must be involved. So in that consultative forum, it is the law that says, bring in members, for example, from the Kenya, the Institute of Planners Association. Bring in representatives from AAK.
AAK being Architectural Association of Kenya.
Association of Kenya. There must be representation from ISK. There must be representation.
Whereby ISK
is the Institute of Surveyors. There must be representation from the Kenya private sector development, Kenya private development sector, there must be representation from the association of people with disabilities.
Yes.
Kumbuka, when you're dealing with development, it's not just about building. There's so many other aspects. Crucially, of course, is that there must be representation from members of residents association. Now, without that forum, whatever activity, whatever attempts any county government makes to talk of, this is how particular areas or particular activities are to be undertaken, in my view, whatever you do is illegal, is irregular, and will be null and void at its conclusion.
Now, has Nairobi County, let's bring it now down to Nairobi County and focus the lens on Nairobi County.
Yes.
Has the Nairobi County government ever, from the enactment of PLUPA in 2019, has it ever constituted the consultative forum?
No, they have never. And I would really want to know. I'm sure there are quite a number of leaders, county government from the county government. I would really want to know whether they know about the requirement. It's a compulsory requirement under the law that there be that consultative forum. But as far as I am concerned, I've never heard of such a forum. And even when I talk to associations like the AAK, ISK,
Kenya Institute of Planners,
none of them tells me they have ever been invited to give a name or a nominee, to sit in that forum, which actually means there's no such forum.
Now, who would then be responsible for putting together for constituting the consultative forum? Whose responsibility is it? Where does the buck stop?
The law says it is the county executive committee member,
yes, in
charge of urban development, who must initiate the process.
Yes.
And initiating the process, the law says you work with the director of urban planning and initiate that process. Indeed, once you initiate that process, of course, you work with the county assembly,
yes,
in now setting up that forum. So responding to your question, it is the county executive committee member who holds the key and must initiate that process. If he fails, then it means we all remain where we were.
So technically what we are saying now is that the CECM, I will refer to the county executive member for moving forward as the CECM. So the CECM has literally neglected his duty to put together the consultative forum, the CECM of Nairobi County.
Yes.
Now, in days gone by, before devolution, we would have the main decision maker in terms of where planning is concerned, being the director of city planning. And then came devolution and PLUPA came with it. Do we have a director of city planning? Or now that we have counties, is there a county director of planning?
Well,
a substantive county director of planning in Nairobi City?
You see, the law on physical and land use was enacted in 2019.
Yes.
That was 9 years from the time we went through devolution.
Yes.
We may have had those positions, before 2019, but it is that act that now created that position. Question is, has especially the Nairobi County filled up the position of the director, of county planning? And my answer is no. I have not heard. And even going through the executive order number 1 of the governor, I have not seen, an officer or the name of an officer who was appointed to necessarily, to be the director in as far as, the law on physical and land use and planning is concerned. So that position has never been filled. It is created by the act, but it has
never been filled.
Yes.
So what we are saying then is that the people that ideally should be tasked or who are mandated by law to execute the function of planning in Nairobi City County are not there.
Yes, they're not there.
They are not there.
Right.
We may have a CECM,
yes,
but we also need to have a county director of planning.
Yes.
who then is responsible, I mean, the CCM and the county director of planning then, to constitute the consultative forum.
Yes.
So these things do not exist.
Yes.
So then who is giving the approvals, these approvals? Who is in charge of development then?
From my experience so far, you'll get, documents, papers that are telling developers, as it were, we have granted you permission.
Yes.
But when you look at that document, that paper, it doesn't even specify or doesn't even, for example, have a signature of who necessarily is telling you, I've given you permission.
Yes.
Of course, the law says it can only be the county executive committee member, who grants, an approval once you have applied for it, who grants that approval and signs, that document. It's called a submission certificate.
Yes.
In the last 5 years, I've not seen a document titled submission certificate signed by a county executive committee member or even a director, which would necessarily be the document that says...
By director, it's the director of city planning.
Yes, exactly. Yeah. So without those kind of documents, I agree with you. Whatever has been happening in Nairobi from 2019, in as far as what we call and we keep calling development, is illegal and irregular.
Now, when it comes to process, there is in CLUPA, in the Physical Land Use and Planning Act, a very clear procedure that is to be followed. I forget the section, but there's a section, an annex, where we have procedures that when a submission is made for an approval for a development, these are the processes that must be followed.
Correct.
Could you take us through them?
Yes. The law says if anyone wants to undertake any development, and when you talk about development, it has several aspects. Development could be you wanting to subdivide, your parcel of land. And that subdivision could be by way of either, cutting or coming up with many sizes of plots. It could also be, and this is crucial, where you want to put up high-rise development, high-rise buildings. High-rise buildings require you first make an application to subdivide your plot so that every unit that you create from that high-rise building in itself acquires a title. That is one aspect, of development.
So those are the titles that we are now referring to as sectional titles.
Yeah, those will be exactly. Ultimately, you'll get a title. It's a sectional title, but it has to go through the process of subdivision.
Yes.
There's the other aspect of development, which is demolishing or bringing down.
Before we go, I find that is a very, very interesting point you have made.
Yes.
The fact that if I have 1 acre, which initially had, or even let's just speak about green land, virgin land.
Yes.
So I want to put up a block of apartments with 200 units.
Yes.
So before I get approval for that, I have to subdivide that land into 200?
Yes, exactly. You
My goodness.
So that whatever
and nobody does that.
I mean... No, I haven't come across anybody who now says, by the way, I have, say, a unit title, which would be the ultimate result of having gone through the subdivision process.
Absolutely.
Remember, again, it is an offense to start constructing a high-rise building with units when you have not acquired, those sectional units. It is a criminal offense.
Yes.
Under the Sectional Properties Act, that offense is punishable by imprisonment of a jail sentence of 3 years or even a fine of 20 million shillings.
Wow.
Today, I have not had anybody taken to court and charged with those offenses. But crucially, of course, is those people who now are told, we are putting up units. We want you to start paying deposits. And, as you continue with the payment, ultimately, we will come up with those units and you can enter. It is also an offense to enter into agreements with anybody who is promising to put up units before he or she has gone through that subdivision process.
we have a lot of criminals walking around Nairobi.
Wengi. Committee is still open. Yes.
Committee is still open.
Yes.
I think in terms of development, maybe what we should be concentrating on right now
Yes.
is to expand our prisons.
Okay, exactly. I mean,
because we have criminals walking all over the place.
It's very unfortunate because I've talked about development. Subdivision, I'm saying, is only one aspect.
Yes.
There's the other one on demolition.
Yes.
You see, all over Nairobi, majority of the high-rise buildings are as a result of demolition of the structures that are existing.
Yes.
It is actually a requirement under the law that before you demolish, the structures we are talking about, you must, first of all, apply for development permission.
Yes.
And it must be granted, because it doesn't mean once you apply that automatically you will receive it. There are occasions when that application will be denied. Say, for example, you want to bring down a 4-level building because you want to put up 40 floors.
Mm-hmm.
You see, when you make that application, the county executive member is also supposed to inform as many government agencies and authorities as possible and seek their comments. These government agencies, authorities include NEMA, include Kura, include Warma, include even in other areas where you have residents association which are registered. They must be involved. I'm talking about demolition. So if you demolish a structure and then you thereafter apply to now put up another building, you have already committed an offense. You have already disobeyed the law. So the county government ought not to grant a development permission for the construction of a high-rise building resultant from a demolition which was not authorized and was not allowed. So today, there are so many places where we should be talking of residents or the general public make complaints. We know this building, it started from a demolition and now it is high up. The demolition was not done in accordance with the law.
Procedurally, yes.
There's the same law, the PRUPA, which says because you commence development of that high-rise building without, first of all, obtaining the proper permissions. In this case, I'm talking about permissions for that demolition. The law says bring it down. Mm-hmm. Restore the land to what it was before you get to where you are
and
today.
That should be section, I think, 58.
That is section 57.
57.
Yes. Section 58 of the law is the one that actually says, when you want to make any development, to do any development in Nairobi, you make an application. You submit an application. And that application, by the way, is not by way of writing a letters. It's not by way of sending, WhatsApp messages to the county executive.
Yes.
No. It must be done. It must be in a prescribed form.
Yes.
That is section 58. So any of, again, the papers, documents we see being circulated, talking of, we have notified you that your application for development has been approved. But when you ask, show me the prescribed form which you submitted as an application, of course, there's none.
Absolutely. And I concur with you with that, if I may just button, because we as architects, we make our applications on a platform, the MPDMS platform.
Yes.
And, there you fill in the details, it is a portal.
Yes, right.
So you fill in your details as the architect, your name, your registration number, the normal details, and then plot allowed number for where you're developing. You upload the title, then you upload the drawings, then you upload the rates, the most recent rates payment receipt.
Oh dear.
Then there is no form that we fill.
Then if that is what you have been doing and you will continue doing, you should also be named as criminals. And you should also be held liable for, again, all the chaos we are talking about in the city. Yes. Because you are the ones who ought to know that application for permission to develop must be in a prescribed form. Actually, under the land use, the physical land use and planning, development, permission, and control regulation.
Yes.
The form is known as PLUPA/DC/1A. Mm-hmm. And an architect is not the one who is supposed to submit that application. It is the landowner. Mm-hmm. Because you talk about plans. Plans are secondary.
Very secondary.
They're very secondary. Mm-hmm. Those are not the ones. And again, what type of plans are you talking about? Remember, I've said there are so many aspects on development. I may be wanting, permission to develop my land just by wanting to, remove trees.
Yes.
Do I need a building plan?
You don't need
I
a
don't
plan,
need a building plan,
but
yes.
you need a permit.
Yes, I need a permit.
Yes.
Oh no, I need permission.
Yes.
I need permission. I may be wanting to only put up a fence. Do I need an architectural drawing for a fence?
No, you don't.
So it is not everything.
No. By fence, let's be very careful
Mabati
about
fence.
that. Okay,
Yes.
the hoarding.
Yes. No. It doesn't have to be about Mabati fence is not necessarily hoarding. Hoarding has now elements of I want to go further, but I only want a Mabati fence, nothing more.
Just to for the vision.
And also for my security.
Remember, I don't know how much security you'll get from that.
I'm talking about, for example, properties in Jericho.
Yes.
I may not need, a stone fence. Yeah, a Mabati fence is enough. Do I need an architect to come and draw a sketch of my Mabati fence?
We would not mind me given that work.
No, but in Plupa,
that's
one you don't need a permit.
But for a boundary wall.
Yes. Yeah,
a boundary wall, you must have, you must have permission. We make submissions for boundary walls.
What the law, especially the regulations provide, is when there's actually regulations relating to buildings.
Yes.
Yeah, these ones are they set, the schedule, and also provide for buildings, for structures that need permission.
Yes.
I would, for example, give the example of if you want to put up a dog house for only one animal, you don't need permission. But if you want to put up, a house for 15 dogs, then you need permission.
Okay.
If I want to demolish, that kennel.
Why would there be a difference between a dog house for one?
Yes.
Okay, one kennel.
Yes.
Versus 15 kennels.
Yes. It's about numbers.
It's about numbers.
Yes. Because remember, when you're talking about development, there's also the other aspect of the environment. They work together. The reason why you need or the county government requires participation and comments of National Environmental Management Authority is because there are some structures where an opinion relating to the effect of the environment are needed, are required. So yes, a kennel for one dog is different from a kennel for 20 dogs. Same thing with a chicken house. You can have a small shed where the cuckoo you brought from, Laikipia, it's there for only 2 days.
Are there cuckoos in Laikipia?
Yes.
But
if you want now to put up, if you want to do chicken farming, you need authority. You need permission.
Absolutely.
Yes, and that permission must also have contribution of NEMA and several other agencies.
When we spoke about processes, so there's the aspect of subdivision, which is being completely and totally ignored.
Yes.
What other process haven't we spoken about yet?
Right. You see, now, once you have filled and submitted the application, for development, and you have stated specifically what you want to do, what kind of development you want to undertake, the county executive committee member looks at, your need, as it were, and then identifies what is required from you and from other authorities, agencies.
Yes.
So that if you now want to develop your parcel of land by building, it is where the county government tells you, do also submit the building plans. Do also submit the plans developed by civil engineer, electrical. In fact, those are again mandatory. It is not just the plan. It must be accompanied by an engineer's report, by a civil, again, you call them civil engineer's report.
The report plus the drawings.
Yes, plus the drawings.
Yes.
And those drawings,
what we call them structural drawings. And those are also submitted for approval.
Exactly. Now, what the county executive committee member is now supposed to do with those drawings is look at the document, the copy of the title that you submitted. It, of course, would be accompanied, say, by a deed plan. A deed plan will be showing, the measurements.
Yes.
Then see whether the drawings by the architect, necessarily now comply with other requirements relating to construction of the building on that plot. Remember, there already are in existence rules, regulations.
Yes.
Yeah, that make provisions relating to how much of that land can you put up a building.
Absolutely.
In Nairobi, there are very few areas where you can put up a building, beacon to beacon. Very few areas. Those are actually where you come up with a proposal related to, say, community housing. But where the property is yours, and you now want to put up high-rise building or even your own single residential, the rules say you can only put up 75% of the land of the building on the land. You can only put up 50%. Like in Kilimani today, by the way,
it is
still 50%.
It is still 50%.
It
Actually,
is still 50%.
Most titles.
Yes.
No, not most.
Yeah.
All
yes,
titles in Kilimani,
right?
Read 50%.
It is, and that is a law.
Yes.
It is not a comment, from
from the agenda meeting.
It is a law. So I can confidently say 90% of what we are calling high-rise buildings, especially in such areas like Kilimani, are irregular, because one, they have been put up beacon to beacon, and we have an answer to such building. Bring them down. For them to be brought down, you need orders.
Yes.
That is why you cannot expect the CECUM to come and tell you, tomorrow I'm bringing the demolisher or the excavator.
Yes.
The CACM will be saying, until I get a court order, they are telling me, bring that building down.
Bring the building down.
Yeah. Then for me, I'll be comfortable in my office.
For any of the illegal structures,
yes,
and they are teeming, they're all over Nairobi.
There are many, there are thousands and millions.
They all need a court order.
Yes, you need exactly
to be demolished.
Yes.
But that channel is available.
That not even available.
Yes.
I'm saying that's Section 57. When you're going to court, is the one you're going to ask the court or the judge to give you an order based on the requirement that there is a construction, there is a building, that commenced, say, without permission.
Yes.
And because the law says such a building must be brought now grant us an order. Either the CECM or the county government brings it down, or we ourselves bring it down.
Wow. This then brings me to the next issue that has been of a lot of contention, and especially so in Nairobi. Plupa gives provision, or rather has a requirement for the development of local physical county development plan, and then local physical development plan.
Yes.
Tell us about that.
Actually, we should have started there. You see, that Plupa, after, the provision relating to filling up positions in the forum.
Yes, in the consultative forum.
Yes, it is that forum which again must give opinions, views to the CECM on the mandatory requirement that county develops a physical and land use development plan. That plan is to last for only 10 years. It must be reviewed, is maximum of 10 years. It must be reviewed after every 10 years. You see, now for Nairobi, 5 years has gone. Yes. We don't have a county physical and land use development plan. It is a mandatory requirement. It is within that plan.
Let's give definitions here.
Yes.
The county development plan.
Yes.
The county land use and development plan.
Yes.
What exactly is in it?
It is the plan which would have established, for example, the different areas, the different needs of the county. We talk about the need, for many houses.
Yes.
It is that plan that will actually establish whether in Nairobi today or from 2019, we need more houses, and if so, where, how, and which. It is within that plan where, if it is specific areas, the plan will provide. Would we still need the services provided by such companies like Nairobi Water? Yes. Or we can come up, because it's a specific area, with a different type of a sewer system. It is the same plan that would say, or will provide, whether you like it or not, you are within, say, the Parklands local area. In the Parklands local area, we must have the entire area necessarily dedicated to trees and forests.
Yes.
That will be in a plan. It is the plan that will have taken into consideration the general population of the county, also taken into consideration, the increase or the decrease.
The projections.
Yes, the projections. And it is out of all that the plan, will arise. And it is within that plan where you will find now the local areas having been identified and created. And once those local areas are identified and created, the law says those local areas come up with their own plans.
So these local areas,
yes,
can we also refer, for purposes of this discussion, can we also refer to them as the zones?
You can use the term zone.
We can use the term zone.
But since it's the law that talks of local areas,
let us just, let's
stick
to the law. Because we are here to discuss the law.
Yes,
the law is the law.
Yes. So talk about local areas. That's what you call whatever is to be developed by the community, as it were.
Yes.
Yeah, as a local physical and land use plan.
Yes.
Now, who is supposed to initiate the process of coming up with a local area, physical land use plan? One, the CECM. He's the one who has the first duty. Two, the representatives, of the local assembly, the MCAs. They also are called upon by the provisions of this act to make proposals that within either their own political areas, or within what they have identified as the local areas, ask the CECM, right, to create that local area, and then they'll now be able to go through the process of developing their own plan. Thirdly, if say all the two fail, the local residents association. The local residents association have power to tell or to inform the CECM, now that you have failed to initiate the process, for development of our local area plan. Now we want you to do it, and if you refuse, then we will do it ourselves. Of course, for the residents association to have the capacity, to do that, to develop that plan, you'll still need the intervention of a court. That's why you go to court and ask the court, now give us power. All these other leaders or institutions have failed, but we want to do it because the law tells us we must have it in place. Indeed, that's another area where we have terribly failed. Yes. Residents associations are not just about, let's look at our security issues. It's not about, let's clean up our compounds. No, there's a much more important aspect that local residents association ought to play, which is to push and call upon the CECM, the county government, to enable them come up with a local, physical, and land use plan for the area. And that's where they'll be able to say, ours, we don't have a common, say, playground.
Yes.
We want the National Land Commission come and compulsory acquired 4 acres, from this area, because we've seen it's very proper, clear, for creation of a stadium, for creation, of a community, hall. The law now gives the National Land Commission power to compulsorily acquire that land. And because it's the people within, that area who are saying what we need here are not residential houses, but a social hall or a facility that gives us opportunity, to come up anytime we have meetings, weddings, and the like. We don't have to go and hire halls from other places. It's the local people who will be saying, some of these roads are too narrow, right? We need to either convert them to non-motorized, if it is within their own area. Places like parklands, majority of the avenues we talk about are still very narrow. And it is possible for the residents of that area to say, we will close, for example, First Avenue, we convert it to a pedestrian road.
Yes.
And we
with
expand,
cycling lanes, maybe.
Yes. There are so many ideas that now people within a specific area can come up with when they're developing that plan. I'm saying it is much more, than saying it's about security, than saying it is about
lack of water,
the usual. Water, yes.
Yeah. So that for me is a very pertinent point, because it is actually the residents themselves who know what their needs are.
Right.
Reason being, they're the ones who live there.
Right.
They're the ones who know where the shoe pinches most.
Yes.
Because we are seeing proliferation of these high rises and the children living in there, where are they going to school? They're crossing the city to go to school in less dense areas because the schools within the areas where they live are already full.
Yes.
But then from, I mean, the local physical development plans, there is no discussion on that.
No.
They are long overdue.
Yes.
Long overdue.
Yes.
So when we look at the hierarchy of things, CECM first, he should initiate. He fails in that. Where does the county director of planning come in?
No, when the CECM is coming up with those initiatives, they work together with the director.
They work together with the director.
It's really a question
who
of
we don't have right now.
Who we don't have.
So in the absence of the director, then
he does it himself. I mean,
he does it himself,
yes.
And then it can also be delegated to the members of the county assembly,
yes, county assembly,
who are our representatives.
Yes. And if they fail,
yes, and if they fail. Now, even before
they have failed anyway,
they have failed. They have failed.
Yes.
So what that tells us is that the MCA, your MCA, is a very, very important person.
Yeah.
He literally is a decision maker when it comes to how you live, because he has the power, mandated by law, to make a decision on the initiation of an LPDP in your area. But most interesting to me is the fact that the residential associations. But what you're telling me is that for a residential for the residential associations to be given the mandate to develop their own LPDP, it must come with an order.
It's not that for them to already they have the mandate.
Yes.
I mean, it is there. It is a process where you come up with a product which is legal. You see, you don't want to operate like I said earlier.
Yes.
On the common talk. Kilimani, there's zone 4. You can only go up to 4 levels. When I ask you, show me, the law or the gazette notice of the law that you claim created.
Yes.
Yeah, the zone 4 for Kilimani, and you can put up 4 level. There's none. But because that term, that belief has been with us for ages.
Yes,
we believe it is. It is not. So to avoid a situation where a particular area, are saying this. We have identified from A to Z as our area. We want it gazetted, recognized as our area.
Yes.
Because the CECM has failed to do that, then you need to go to court with that proposal and you tell the court, grant an order. See, now that becomes law.
Yes.
An order is law, all right? And it is as a result of failure of those in authority.
Of the systems, yes.
Exactly. Of course, when you the reason I'm saying you need to go to court is you want to avoid a situation where there'll be so many conflicts. Even in a community, you can have people, some saying, no, when you talk about creating a school, within our community, no, for all of us, we are okay, with what we have. Now, if you go through the court and there's an order that allows you to say create or to have a school within that area, then anybody in dispute or challenging that order will still have to go to court and give reasons why you are in disagreement with the others. Remember, you're all human beings.
Yes.
Right.
So which means then that again, consultation in terms of data collection at the point of development of LPDPs is very, very critical.
I can confirm, let me not mention the local area.
Yes.
And they have come up with a program that's going to last 4 years. And it's all about data collection, information collection. So that when they are presenting now their petition in court, they'll have everything. So it may take another 4 or 5 years for the petition to be heard. But in another 1 year, unless there's intervention now of the local authorities, they'll get an order. And they'll have a local land use development plan allowed by law. And they'll operate, on that land.
On that premise.
Yes.
Oh, then that I think is very important. And I think residents associations need to know that the power that they hold within their hands.
Correct.
Now, when it then comes now to, if we look at, say, Nairobi County, the decisions that are made in terms of planning, the county land use and development plan, we have what we call the satellite towns.
Yes.
We have Kiambu. We have.
Kiambu is a different county.
It is a different county indeed, but we have Syokimau, Machakos. Those are called now loosely the bedrooms of Nairobi, where people live there, but they work in the city. Do we have any mechanism that provides for that whatever is happening in Nairobi, if it affects the next county, how is that dealt with when it comes to planning? Because they sort of merge into each other.
No, the county, the law actually provides for intercounty land use development plans. So I said it starts from, the law says you start from at the national level, then you come to intercounty, and then you come to county, and then local. Right. So yes, the so-called, you're calling them satellite towns, but for the planning, it's about the counties that depend on each other.
Yes.
They come up with, plans, that will serve their their respective citizens' interests.
Yes,
it's there.
Yeah, because it would be a shame to say if Kiambu did a very good county development plan. We have seen it. There are counties that have already made their declarations in terms of, and it is a requirement in Plupa that each county needs to make a declaration and in a Gazette notice.
Yes, for it to become law.
For the intention to develop county and local physical development plans.
That's how you initiate now the process.
That's how you initiate. That's the process.
Yes.
Now, there are counties around us. Kajiado, there are counties around us, maybe Kiambu, that have already made that declaration.
Yes.
I know Kajiado has.
Yes.
Yet Nairobi is still silent.
Yeah, that's why for Kajiado, the notice that they have given relates to the county.
Yes, it relates to their county.
Yes, to their county. If it wants now, a development plan for inter-county, they'll identify which other county they want to
work with.
Right, and they have the power to involve or to have that other county participate in the process.
But why isn't anybody initiating this? Why doesn't anybody want to initiate anything with Nairobi County?
You have the answer. You have the answer.
No, it's very disturbing.
Yes,
because everything, all other counties around us seem to be active, doing the right thing, following the law. Why are we not following the law?
No, ask the county government ministers I've mentioned.
Yes.
Why don't you call them? Ask them, why aren't you performing? Why aren't you initiating these processes?
Well, yeah. I guess, Then that brings us down again to the residents' associations. Because, again, like I said earlier, we are the ones who know where the shoe pinches the most.
Right.
Which other process are we neglecting?
Now, I've talked about the creation, or rather, the processes that will lead to establishment of those plans.
Yes.
There are other matters where you really ought not to even think that you can initiate a development because the law does not allow you to do so. I'm talking about you wanting to, for example, put up a high-rise building in an area where there are strategic installations. There are areas, say, next to forest. There are areas where there are game parks or parks. You see, for you to be able, or even the county government, the CECM, to grant or to give you permission to put up high-rise buildings, you need involvement of other government agencies, other government authorities. Like in the Kilimani area, because I'm now very familiar with the area. 3 kilometers from State House, 3 kilometers from the headquarters of Department of Defense.
Yes.
Nobody today ought to even be dreaming of putting up a high-rise building. For reasons, it is obvious. These are crucial installation areas. They need to be looked at, addressed in such a manner as in to take consideration of security. We have so many buildings that have been erected 3 kilometers, next to...
Within 3 kilometers of...
If I had instructions today, I'll file a petition and have all those buildings brought down.
Yes.
Because they have actually breached and violated them. And this is actually not even a law that came into place in 2019. We've always had it. I recall in 2023, there was a visitation by the president in the Eastlands area. And of course, was accompanied by the county.
2023,
Yes.
which is the current regime.
Yes. And that time, I think the story was we will put up 40 level residential housing estates. Others, because we already have 25, it is okay. But remember, in Eastlands, we have an airbase. We have other social facilities that putting up high-rise buildings will not suffice. It's only 6 months thereafter that we had Governor Sakaja actually tell all of us, whatever we were talking about, 6 months ago, were mere proposals.
Stories are Jabba.
Yes, stories are Jabba. When we now look, for you are asked, is it like if you look back, you realize in Eastlands, there are only specific areas where you can go, say, up to 25 floors. When you talk about 75 floors in Nairobi, we have the Jomo Kenyatta International Airport. When we talk about, the pathway, how far does it extend? 75 floors in the Eastlands area, it's a dream. Yeah. In Nairobi, we are told it's a fault line. When you talk about putting up, even 16, 18 level floors,
yes,
it's a fault line. We are lucky so far for 2025 years, we've not had an earthquake.
But we have had tremors. Last year, we had...
That's a small one. But we've not had one.
I think there was a 4.9.
Yes.
And if you ask for my opinion,
yes,
hiyo pengine ndio ilikuwa last warning.
Ikikuja ya 8.4.
Yeah.
Right? So when you're talking about approvals to put up these high-rise buildings, those are some of the areas we need necessarily experts to advise. And that's why you have that forum,
yes,
to give views, opinions on what kind of a development plan, as it were, that you can come up with. Talk about, I've again looked at especially parklands. The buildings that have been erected next to each other, there's a fire. You are on the 13th floor. There's no staircase because you have been told a lift is enough.
Yeah.
Or the Kenya Power people have disconnected. There's a blackout, a nationwide blackout. The lift, fine, you may have a generator, but takuna mafuta, you're on the 13th floor. Yeah. Who necessarily made considerations or to make considerations of coming up with a plan and also stating how far you can go because of security reasons. I've not talked about health because that's obvious.
Yes.
When you have a building with 700 2 3-bedroomed units, just do your math. Yeah, there are 300. You're told, according to the architectural drawing,
yes,
there are 326 units.
Yes,
2 3-bedroomed. On average, a 3-bedroom unit is occupied by 6 people.
Yes.
Do the math. Within, that 0.4 acre, you'll have 2,000 people.
Yes, over 2,000 people.
2,000 people.
Quick math.
And the next one, the next one, the next one. There's some, of course, issues like infrastructure that are obvious. But now go deeper. How will those people live?
What quality of life is
what
that?
Quality of life?
Yes.
The law, of course, tells us, no, you have a right to a clean and a healthy environment.
Yes.
It is those people who are...
It is there first in the Constitution.
Kabisa.
Then it is there in Plupa. It is there in the NEMA Act. It keeps on being repeated.
It is even
but totally disregard.
Yeah. Na sisi tuko hapo tu.
Yeah. And
so
we're disregarding it.
You started with the question, do we have laws? Yes, we do. Why don't we necessarily make use of and enjoy those laws? I wouldn't want to say it's because we don't know those laws exist. No, we have perhaps other reasons, other factors.
Yes.
Like, you don't want to disturb the status quo. It is okay if you pay for my movement from this plot to another, right? I'm okay. I am interested in the millions that I'll get out if you buy my plot.
Yes.
Whatever you do with it, I don't care. It's not that we have... we are not able to take matters or complaints to court. We do. Incidentally, filing petitions relating to violation intervention of fundamental rights is the cheapest. Is the cheapest in as far as legal cost is concerned. Forget about legal fees, that you may necessarily pay a lawyer, but I'm saying the process.
The
is
process
the cheapest.
itself.
Yeah, is the cheapest.
Now, while we are on that subject, in terms of the violations, we spoke about the processes and the violations
Yes.
that are currently ongoing. There was strategic installations. Those laws that are not being followed.
Mhm.
Then there is environmental.
Mhm.
We are talking about riparian reserves.
Yeah, right.
We are talking about what else are we talking about in terms of the
No, the crucial aspects, because you'll find under section 61 of the Act, which tells the county executive committee member, when you receive an application for development, they look at it and they are able to identify which aspects ought to be addressed before they make a
and which
consideration.
agencies
they
need to contact.
That's why, like you've mentioned, if the development is, say, within an area where there's a river, a stream, and the like, that is where they must involve NEMA, they must involve Warma. If it is an area where
there's a forest.
Yeah, the forest, of course,
Kenya Forest,
or a game park, like City Park. There's no way any one of those developments in parklands ought to have been approved without participation of the Kenya
Forest Services,
and the Kenya Wildlife Service.
Okay.
And nowhere have I seen, any request that they give their views or opinions. Okay, we were talking about the riparian land. See, in Nairobi, we have, I think, more than 12 rivers and streams.
Yes.
Yeah, especially the Karura area. Karura Forest has more than 8 rivers.
Yes.
Then if we go to Ngong River,
starting from the Ngong Hills.
Yes. Yeah.
I think there are 4 main rivers
and streams.
Yeah, and then which now split into streams.
Right. So you need to involve, or you need a participation of NEMA, you need participation of Warma, right? And then all the residents associations, which are necessarily whose membership or residencies are beneficiaries, of those rivers.
Yes.
Remember, if they were clean rivers, we wouldn't necessarily be talking of looking for water, buying water and the like. We would be depending on what is, next to us. If it is within an area where the road, right, is either under Kura, Kera, or Kenha, you also need participation of those agencies.
Yes.
Right? If it is like in Nairobi, Kenha is in charge of the Nairobi Expressway all the way to Limuru and the like. All the construction, all the development along the Nairobi Expressway ought to have participation of Kenha. I really doubt whether people, for example, putting up GTC,
yes,
but had Kenha participate, and you can now actually see the results.
And Kenha number 1,
yes,
also KCCA.
It's how exactly the civil.
KCCA.
Yes, exactly. Yes,
yeah.
You also need their participation.
Yes,
I was saying if you pass through, Chiromo Road, you can see the results of non-participation. And we'll be with that problem
for life
until kingdom come.
Until kingdom come.
But we can still bring it down if we went and sought
a court order.
Yes,
because it is a violation.
It's a violation.
As a matter of fact, even if we speak about the GTC in its current shape and form, it is an illegal building because it did not follow.
It didn't follow the law. Right.
Which now brings me to the culmination of the happenings, recent happenings in Nairobi.
Yes.
This public participation for sessional paper number 1 that was carried out this week.
Yes.
Where there was the participation, submissions were made by the professional associations. Then the developers had their day, and the residents associations have had their day.
Right.
Is this process legal?
See, the saddest bit about whoever came up with that proposal, that people bring in their views, opinions on how we can come up with a Nairobi County development control policy. See, logically, you cannot expect to have a control policy when you do not have the basis upon which that control will be coming from?
Because what are you controlling?
What are you controlling? Until and unless we have a county development plan. If we now want views, opinions on how, to come up with the policies relating to controlling development within the county, then we will be called and we give our views. But we first of all must have a county land, physical and land use development plan. Secondly, going to City Hall to give views about different areas of Nairobi, the local areas. Zones. And you're giving general views. That's why I'm talking, perhaps I made that comment.
Because first and foremost, zones.
Yes, zones.
The term zones is not in the law.
Yeah, exactly. But if you're talking of views, opinions relating to, start with local development plan, then you involve the people from within. So they don't come to City Hall. They have their own perhaps central place where they'll agree. This is how we will meet. And this is how we'll give our views. Yes. So calling again this meeting to talk about Nairobi generally, honestly, it can...
First and foremost, calling people to City Hall.
Yes, only City Hall.
Illegal.
Indeed, we have the legal notices that created, or rather that provides the regulations on how, if for purposes of developing the plan, the various steps you must take. Same way, we have a regulation, it's called the physical and land use, local physical and land use development plan.
Yes.
And it has the various steps that must be gone through. Crucial of those steps is that it must involve the people within that area. That is where public participation
should take place.
You
and
don't
not
have
at City Hall.
At now coming to City Hall to give this views about pipeline. All right? They can't match.
Yes.
So yes, you'll still have what soon we'll be hearing is Nairobi County Development Policy 2023. I'll tell you, it will not be any different from what we've had in the last 30 or so years.
Yes.
We've always had this policy, but they cannot work because they lack, the foundation.
And they lack the foundation and they lack the data.
Exactly.
Yeah, because the law does not recognize it. What I liked most is that the fact that you said that you're calling people to City Hall.
Yes.
People of Loresho to make comments about what's happening in pipeline.
Exactly.
Or vice versa, or somebody from Mathare is coming to comment about what's happening in Kilimani. But then, of course, there's a ripple down effect. I believe that just the same way we have the intercounty development plans, there is also the interlocal development plans, which needs to be considered. Because, for instance, bear me, I am of the strong belief during the floods that happened last year. Everybody was affected.
Yes.
But the most affected were the communities that live downstream.
Yes.
Like, for instance, there was devastation in Mathare.
Yes.
There was devastation in Mukuru, Kibera. There was a lot of devastation. But when you really get down to investigating and really scrutinizing it, it is an effect of what is happening in Kilimani.
Yes.
We have gotten rid of all our green cover that would help in absorbing flood waters. And we have built almost up to the riparian. We are built into the riparian reserves. So this water is just now racing downstream. So I still feel that, we still need to be able to comment about what's happening in one area vis-a-vis what's happening in the other because of that interconnectivity-ness.
Right.
What would your opinion be?
There's certainly connectivity. But when you're talking about those kind of resources, we already have it clear in the Plupa.
Yes.
Yeah. That if you're talking about natural resources, if it is riparian land, so long as it is a river, there's a 30-meter distance.
Yes.
So it will not matter whether you're living in Mathare or, in Peponi, Yeah, because the Mathare River, by the way, starts all the way from Kikuyu.
Yes.
It has different names. In the Peponi area, it's called Getadhuru, right? It cuts through Karura Forest. For so long as we know it's the law that says this Mathare River or whatever its source, there must be a riparian land extending 30 meters.
30 meters.
Then we'll not have the problem of trees falling, in
Getadhuru and big fauna. Yeah.
No, we will not have people like now who have constructed high-rise buildings on Mathare River in Parklands.
Yes.
And not just constructing, they do not have a sewer.
Yeah.
All their chafu is actually on Mathare River. By the time your chafu gets to Mathare, the Mathare area, in most cases, we still blame the residents of Mathare. But the source
is upstream. The source is upstream.
Yes.
And I think, that is something that we need to, also interrogate a lot further, because whatever we are doing upstream is affecting everybody down the... Right. Yes. Now that, we are running out of time, what are your closing remarks?
For me, it's all about us, taking this battle in our own hands and making every effort to see that where we have laws, for heaven's sake, let's make use of those laws. And let's try as far as possible not to break or violate those laws. Let us all remember that we are the ones we came up with a constitution that gave us very fundamental rights and freedoms, especially the right to a clean and a healthy environment, a right to life. And unless, of course, we take whatever complaints we have where there are violation breaches to those rights, we'll just keep, living for the day. So we must be ready to every time take action. And of course, it's of different aspects and characteristics, but it must be action taken, not to just lie low or sleep.
Thank you for that. So there you have it, Nairobians. You have heard. We have laws that govern our planning. Architects, all approvals that you have been granted, I will not even call them that, they're all illegal as per the provisions of PLUPA. All other practitioners in the built environment, you have heard what needs to be done, what is the right thing that needs to be done where PLUPA is concerned. Developers, musikwe na mbio sana, because the things that you've been developing since 2019 are all illegal. All of them, without exception. Doesn't matter whether it's a single dwelling in Muthaiga or it is a high-rise in Kilimani. The investors, in terms of those who are buying into these developments, you're buying into illegal developments. So when the law is eventually, followed, when it comes down to the crunch, you could lose your investment. The legal fraternity, lawyers in the legal fraternity, the judiciary, you have your answer. We have laws that need to be followed. So Nairobians, let us come together, save our city, and like the proverbial Nairobi saying, the law is very clear, and ignorance is not an excuse. Thank you very much. That was our episode 5 of The Lift. See you in episode 6.